Yes, sir.
We
found a place, but we just cannot get in until the first of the year.
I understand that, ma'am.
Been in my home for so long. I don't see why they can't be a little bit lenient with this.
I think it's Gindart et al. If you're here on the Gail Bannon matter, please unmute yourself. Let me know you're here.
Good afternoon, Your Honor. Skylar Schrader appearing on behalf of Plaintiff Gail Bannon.
Yes, I'm here.
And if you could identify your name for the record.
I'm Carrie Ginhart, Your Honor.
Great. And do we have Chad? Chad is here too?
Yes.
All right. Counsel, I did review this file before coming on the bench, but where are we today?
Your Honor, I'm still asking the court to sign off on all three of those orders. I'm not sure if the court has them. I do say they're filed, the proposed orders. We basically have an order of default against the defendants, any and all occupants, known or unknown. We filed this action back in May. They were served no response. So we're asking for an order of default against those particular defendants. We're also asking for an order for a writ of ejectment against Terry and Chad Ginhart, not for default, but pursuant to the agreement of the parties. We had a stipulated agreement that was filed on November 4th in this matter. The parties had resolved this matter out without the need for a trial. So my understanding is that at this point, we are entitled to the writ of ejectment for all named defendants in this case.
Yeah. Excuse me.
Yes. Can you identify yourself?
This is Chad.
Okay.
So with that agreement, like, we found a place to move to. It's just like, we can't move in until after the first of the year. That's why we originally asked for 90 days. If we had 90 days, like, everything would have worked through smoothly, you know?
So, sir, you haven't called my office at all to let me...
Well, hang on, counsel. Hang on. Let him finish, and then I'll have a follow-up question, and then I'll turn it over to you, counsel. Chad, what did you want me to know?
We've been looking for places. They gave us 60 days on the agreement. We originally asked for 90. We found a place, but it's not available for us to move in until after the first of the year. So I was hoping maybe we can just get a couple weeks continuance and everything will run smoothly and we'll be done with it, you know?
Counsel, I realize you may not have heard that before, but just briefly, what's your response?
My response, Your Honor, is that the defendants have had well over 90 days since we started negotiating this case. Again, this was filed back in May. They've been on notice. We've provided them with $3,000 in settlement of these claims. My client's position is that we really need to get this home ready for sale. This is the last issue in the probate of the estate of Ed Skinner. And again, my client has been waiting many, many months to get some movement on this issue.
Hang on, one at a time. We're not going to talk over each other.
I'm sorry.
Counsel, the concern that I have is in your CR2A agreement is paragraph number 2. The parties agree the defendant shall have until 11:59 p.m. December 19, 2025 to vacate the premises. And then it talks about a writ of restitution after December 20th. So how is this right? What I'm struggling with is to understand why we're yet here on December 17 asking for these remedies.
So the understanding that I have is that we're asking for the writ to be issued at this time, but not executed until December 20th. It would take... And my understanding is that's generally how it operates in unlawful detainer situations. When the parties have reached an agreement, they automatically agree to the issuance of the writ, but they agree that the writ shall not be executed until a certain date. So we can get the writ today, but it just will not be executed until after the agreed upon date by the parties. Absolutely, we still intend to comply with the agreement. We have a couple of days left on it. But my understanding is that we can get, based on the agreement of the parties, we can get that writ issued today. We can just delay its execution until after December 20th by agreement. And again, that's just generally my understanding of how these agreements operate in unlawful detainer. full candor to the court, this is the first CR2A agreement I've done in an ejectment specifically. But the language is similar. The statutes are similar. We're asking just for a writ of ejectment instead of a writ of restitution. And again, it's speaking with unlawful detainer attorneys. That's my understanding of how these agreements operate.
May I say something?
Yes, I want to say
Yes,
something.
just briefly.
Your Honor, I'm sorry, but this has been my home for close to 20 years. I was in an intimate relationship with Ed. And when he passed away, I went into a deep depression. And then they were.
So, ma'am, we're past that.
Like I said, this has been my home for like 20 years.
Ma'am, we're past that. The question before me is what the language of the CR2A agreement that you signed, what it says and what the effect of it is in the next 2 days.
Yes, sir. We found a place, but we just cannot get in until the first of the year.
I understand that, ma'am.
It's been in my home for so long. I don't see why they can't be a little bit lenient with this.
You signed an agreement stating that you would be out on or about December 19, 2025 at 11:59 p.m.
And sir, when I signed that agreement, I had pneumonia and I was very, very sick.
Okay, well, I
felt like I was forced into signing that.
Well, I don't have any information on that in front of me today, so I'm not going to decide on that.
But took care of Ed through all his illnesses, through all the years we lived together, and I don't see why his sister is being so mean.
They're not, ma'am, they're not required. I don't mean to sound harsh or unreasonable, but this is an agreement that you signed. So the only question in front of me today is what is the impact of the written agreement in which you signed it today?
Right.
So counsel, as a matter,
when we signed it, we didn't know we would need extra time. We've been looking and looking.
I understand.
We finally found a place, but we cannot get into it until the 1st.
We're just trying to be homeless.
We just trying not to be homeless. It's wintertime. I can't be outside in the weather.
So, ma'am, I understand that. Unfortunately, I don't have power to break an agreement that you signed with the opposing party if the opposing party is refusing to modify or otherwise change the agreement. That's not within my power, ma'am.
Okay, well, perhaps she will agree to change it up till the 1st. I mean, I took care of her brother. She came to see him one time, and that was to ask him. Ma'am,
I am not trying to be rude, but I am trying to figure out what to do next. And unfortunately, whether or not you took care of him is not relevant. The only question before me is what the language that you signed within paragraph 2, what the ramifications are of it today. Counsel, my concern is, as I read it, it is unclear to me. Sentence 1, parties agree the defendant shall have until 11:59 December 19, 2025 to vacate the premises and return the key. The parties further agree to the immediate issuance of an order of writ of restitution, but that its execution should be delayed until December 2020 or later. So on the order of writ of restitution, is that one of the things you're asking for today?
I would be asking for the writ today, just with a note that its execution would be delayed until the 20th.
So is there a proposed writ of restitution that's been filed yet?
I have just filed the orders for writs of restitution. I can provide the court with the actual writs themselves this afternoon.
Well, because I have the writs of ejectment in front of me, and I recognize that there is a interplay between writs of ejectment and writs of restitution, but the CR2A does not explicitly state a writ of ejectment in it. What's your thought?
And that was a mistake on my part. I was using templates for unlawful detainers specifically. And so the language is, yeah, that is an unfortunate oversight on my part. The writ of restitution is obviously used in unlawful detainer cases where there is an eviction, a lease agreement. We don't have that in this situation. So what we're asking for functionally is the same, but it is called something different. And I recognize that, and I do see that now. So that was an oversight on my part, a scrivener's error. We are asking for, and again, I mean, it may not matter in terms of what the sheriffs actually do with it. And I can let the Gindharts know around the holidays, it often takes the sheriffs a little bit of time to execute these. So just because even if a writ is ordered and it's ordered to be executed after the 20th, it's not likely that it's going to actually happen on the 20th, especially given the holidays.
So everything wasn't prepared. Is there a way we can maybe set it over just
hang on, Chad? The council, the other challenge that I have is in your motion declaration for default, it's not signed under penalty of perjury. I'm sure that's an oversight, but it's not there. I'm looking at page 3 of your motion for default.
I see.
So I am inclined, given that I think that restitution and ejectment are different. I think there's an interplay between them, but there's also, and I'm sure it's unintentional oversight, but I don't have a signed declaration on the motion for default in front of me. I am inclined to set this over 1 week. Do we have a civil docket on the 20th? Do we have any civil docket next week? Do I have an unlawful detainer docket?
I believe so.
So council, the best I could probably do is set over these matters. And if you have any other filings that you want filed for me to consider, to set these matters over to December 31 at 1 p.m. civil docket. I don't think I can, based on the plain language of the CR2A and the lack of a declaration under penalty of perjury on the motion for default, I don't think I have much choice but to set them over to the 31st.
That's understood, Your Honor. So I will amend the motion for default and ensure that I see it's unsigned. I see that. I will ensure that that is signed. And so is the court unwilling to accept the CR2A agreement as written? Do we need to modify that paragraph?
Well, if they're willing to agree with you to that modification, I'm willing to entertain it. But I don't see an agreement right now for ejectment. That's all I'm going to say.
Understood. My apologies, Your Honor. I will get that taken care of and address this issue.
Do you need more time beyond the 31st? I'm just thinking about service deadlines. And
no, Your Honor, I'll make sure everything gets served today or tomorrow.
All right. So, Chad and Terry,
yes,
Your Honor.
We're going to set over everything to December 31. If you have any response, you have to timely file any responses in writing and serve them on the other party. You understand that?
Yes, sir, Your Honor.
yes, sir.
All right. It's going over to December 31, 2025 at 1 p.m.
Thank you.
Thank you so much, Your Honor.
Thank you.
Merry Christmas.
You're welcome. I'll take next cause number